Yes, Mzansi, welcome back. Your Feel Good Breakfast Show. We're opening up right here on S3. And of course, it is Klein Vrydag, but we also are diving into Tech Thursdays. And on top of that, we've got games and a lot of tips. And speaking of tips, what a beautiful tip coming through right now when it comes to the law. Now, Operation Buyo Mthetho, or Buya Mthetho, is in full swing in certain parts of South Africa as government clamps down on major businesses and organizations who have failed to pay for municipal services. Now, this revenue collecting campaign shows that no matter how big or established you are, nobody is above the law when it comes to evading our debts. Now, it's time for another edition of So Now What? And today we're calling upon the legal guidance of an expert in law, director at Jaffer and Associates.co.za. Ladies and gentlemen, let us welcome Dawood Jaffer to the green couch of love. How are you doing, brother?
Good in yourself. Thank you for
fantastic,
having me.
man. This is some interesting stuff. Of course, I've been seeing what possibly seems to be a lot of this commotion going on online. I see some tweets going on about guys are not paying for their services. With the government, however, institutes are now shutting services off to people that haven't been paying for that.
That's correct.
What's the deal with that? And I mean, as a let's say someone that's possibly a tenant, can we do that to our people as well? Do we have the right to do that?
Okay, so with regards to governmental institutions, such as the municipalities, contrary to popular belief, they are allowed to do this to customers who are in arrears and whose arrears remains undisputed. However, for them to do this, and this is in terms of the municipal bylaws, they have to give the customer a written notice of 14 days in order for them to either pay the arrears in full, to make a payment arrangement, or to dispute the arrears before the disconnecting. If they disconnect services before the 14 days has lapsed, or if they haven't given notice, the disconnection would be deemed unlawful. However, with regards to tenants, you are not allowed to do this. So when a landlord and a tenant enters into a lease agreement, the tenant has the right to peaceful and undisturbed possession of the property, as well as the use and enjoyment of the property.
Okay.
So by you disconnecting their water, regardless of whether or not they are in arrears, you are disturbing and infringing on those rights. They are then allowed to make an application to court for what is called a mandement van spolie, which is also commonly known as a spoliation application.
Okay.
So in here they would have to prove that, the tenant, which is the applicant, would have to prove that they were in peaceful and undisturbed possession of the premises, and that the respondent, being the landlord, then disturbed that possession by terminating the services.
Okay, so I think all the tenants out there can relax a little bit, they can feel more comfortable. Does the 14-day rule still apply if you're a tenant as a part from government?
So the 14-day rule is specific to governmental institutions that is governed by the municipal bylaws. With regards to switching off water for tenants and landlords, like I said, unfortunately, that cannot be done.
Okay.
So the 14-day rule would then be for something else, like breach of contract, where, the tenant or landlord would be given a period of time to remedy a breach. So that's the 14-day rule.
Let's get more practical about this, and maybe we can help Mzansi out there. Obviously, it's still a tough year. Some of us are struggling to pay our rent. Yeah. What are the rights of the landlord when it comes to an issue that they have with a tenant? Do they have the right to go to the full extent of, like, let's say, not allowing them into the property, confiscating some goods perhaps, or just cutting off their service intentionally? Do they have the right to do that? Should we, as the people that are paying for that rent, be kind of cautious and aware of the fact that, hey man, this guy might confiscate my stuff and I won't be able to use it? Do they have that a right to do so as the landlord?
Okay, so they may not keep the tenant out of the property. Again, that is infringing on their right to use and enjoyment of the property. The landlord's remedy lies in what is in common law known as a landlord's tacit hypothek. So
tacit hypothek.
Tacit
what these fancy terms coming through you, man? You're getting educated.
So I'm gonna simplify it. So as soon as the tenant comes onto the premises of the landlord, as soon as the lease agreement is in play, the landlord has a right over certain assets, or actually property of the tenant, where there is unpaid rental. In order to enforce this, the tenant would have to apply for what is called an arrear rental interdict summons. So once a summons is issued and served on the landlord, served on the tenants that's not paying, the sheriff will make an inventory of assets owned by the tenant, and once judgment is granted, the sheriff may remove those assets and sell it at an auction, to make up the money. There is another remedy, which is an application in Section 32 of the Magistrates Court Act, which allows the sheriff to immediately attach the assets of the non-paying tenant if the landlord feels that, the tenant may abscond or, leave the premises in order to evade paying, and also, or if a period of 7 days has lapsed since notice was given for the tenant to remedy the breach, that application may be brought. It's brought on an urgent basis and is usually a bit more expensive.
I love it, man. Getting educated and I think a little bit more comfortable when it comes to anyone else that is renting. Of course, Dawood Jaffer is going to be back with some more about so now what, especially when it comes to the legal game, all about renting and being a landlord. But for now, let's tuck into the rest of the magic and we'll see you in just a bit.
It's my feel-good breakfast show.
Yes, welcome back, Mzansi. We are still carrying on with all the magic and continuing our conversation on so now what with the legal segment. And of course, we've got the expert in the building, an expert on law. It's Dawood Jaffer. And in case you missed it earlier, we discussed the rights of a landlord and what they have when it comes to claiming unpaid debts from a tenant who fails to pay. But next up, we're switching things around and looking at the rights a tenant has when in arrears with their landlord. Right. So a lot of you out there, Mzansi, want to listen up to this one. And of course, the question this morning is, obviously, we have all these lease agreements. Regardless of whether the lease agreement is signed or not, what are some of the rights that the tenant still possesses or still has, regardless of this being signed?
Okay, so, landlords aren't perfect. They breach agreements as well. It would obviously just be much easier to have a lease agreement, so that the tenant can refer to certain provisions and clauses, in the lease agreement where there is a breach. However, regardless of whether or not there's a written lease agreement, the rights that a tenant still has, regardless of this, is the right to peaceful and undisturbed possession of the property, the right to use and enjoyment of the property, the right to receive the property in a livable manner, the right to maintenance of the property, by the landlord. It's also the right to have its deposit, the tenant's deposit put into an interest-bearing account, as well as the right to an ingoing and outgoing inspection of the property.
Okay, nice. So we have this right, like you mentioned, as the tenant, but let's say the right isn't fulfilled. There's an issue with the apartment that I'm living in, the geyser burst or something crazy. Do I, obviously then, I have the right to enjoy the property. I am no longer enjoying it to its fullest extent. Like you mentioned, do I then have the right to withhold paying my rent?
Okay, so...
Because I'm not getting the service, so what am I paying for? You know what I mean?
No, I understand what you're saying. So in terms of lease agreements, usually there is a clause that would state that rental is payable from the tenant to the landlord without deduction or set off, meaning that, generally you are not allowed to withhold the rental from the landlord because there is an obligation on your side as the tenant as well.
Yeah.
However, in terms of where maintenance is urgent, so like you said, for example, a burst geyser, that obviously hinders your right to properly use and enjoy the property. You are then allowed to then repair the damage yourself and then claim a reduction in the rental, from the landlord.
Based on those costs that you
based on the costs that you spend.
Right.
So in a case where the landlord then, refuses to a reduction in the rental on that basis, you are then allowed to, in terms of a separate legal action, claim damages from the landlord for the damages that you suffered, as a reason of that.
All right, so I'm going to throw a crazy curveball here and throw a scenario in the play. So let's say I'm the tenant, the fan of the ceiling is not working so well, and I decide, look, it's broken. Tenant's not going to do anything, so I'm going to replace it and get aircon. All right, a little bit of an upgrade, but it was needed because it wasn't fixed. What happens in that case when the landlord determines I'm not going to pay you that amount of money anymore? Do I have a right to exercise that? Can I go somewhere to get assistance, or am I maybe in the wrong in that example as well? Tricky one.
A bit of a tricky example because, when you took occupation of the property, there was a fan in the property, there wasn't an aircon in the property.
Okay.
So, you are now upgrading, you are bettering your living conditions at the expense of the landlord. So again, I would say it's tricky. However, if there are ever disputes with regards to any, monies being paid and things like that,
yeah,
you are always allowed to approach the rental housing tribunal.
Okay.
So in this case, a case officer will be, appointed to your case. A notice will be sent to the landlord. The case officer will investigate the matter and then make a finding. However, nothing stops you from approaching, the courts as well and requesting your attorney, then to seek damages against the landlord.
All right, man, look, it's been an absolutely incredible conversation. Thank you for joining us.
No problem. Thank you for having me.
No, man, it's always good to get educated appreciated, especially in this crazy world where we are lacking so much information. And that's why you're here, the specialist, of course. Dawood Jaffer in the building, thank you so much. An expert that you can reach out to if you are struggling with any issues when it comes to being a tenant, being, anybody that's just essentially in the property game itself. The man is here to answer any of your questions, of course. And thank you again, my man.
Thank you for having me.
Exceptional stuff.
Thank you for having me. Appreciate it.